Welcome back to the Constitutional Clarion. Today I'm going to talk about an aspect of the voice referendum that people have raised concerns about, and that is the scope of the representations that the voice can make. Now, as you'll know, the proposed constitutional amendment says that the voice is going to be able to make representations to the Parliament and to the executive government on matters relating to Aboriginal and Torres Strait Islander peoples. And rightly, people have said that that's a very broad category. And so some have suggested that, well, maybe that should be narrowed down so it's a bit more specific. So to say, for example, the voice can make representations in relation to matters that directly affect Aboriginal and Torres Strait Islander peoples. However, there were two reasons why the words were drafted broadly in this way. The first is that laws of general application may have a very specific impact on Aboriginal and Torres Strait Islander peoples and therefore might well warrant the voice making representations about them. So, as an example, and I can see that I've used this one before, but say, for example, the Commonwealth Parliament said that you need photo ID in order to be able to vote. Now, that kind of a law would be a law of general application, but it would probably have its greatest impact on Indigenous people, particularly those who live in remote areas who just don't have access to photo ID. Now, if the Commonwealth made such a law or proposed to make such a law, and it was going to be a law of general application, it would be certainly appropriate for the voice to be able to make a representation either opposing the law because it would have an effect of suppressing the votes of Indigenous people, or indeed saying, well, if you're going to make that kind of a law, then we recommend to you that you take these measures to either ensure that Indigenous people in those communities do have access to photo ID, or that there are alternative ways included in the law to ensure that Aboriginal people can be appropriately identified and fully be able to exercise their right to vote. Representations of this kind by the voice could, well, influence the Parliament and the executive government so that they make sure that the law applies suitably in those communities so that Aboriginal people can exercise their right to vote as fully as those of other Australians. There are probably many laws and policies that apply generally to everyone, but which have particular and damaging impacts upon Indigenous communities, especially those in remote areas. And that's the whole point of the voice. The point of it is that the voice is able to identify these aspects and point them out to the people who are making the laws and policies. We all know that with the best will in the world, people who are located in Canberra or other capital cities who are making laws and policies are not going to fully understand on the ground how those laws and policies affect people, particularly in remote areas of Australia. And the point of the voice is to enable them to learn about this so that they can adjust laws and policies appropriately. The second reason for drafting broadly what the voice can make representations about is because if you narrow the scope of the representations that can be made by the voice, this will provoke endless litigation about which side of the drawing line any particular representation falls on. The very people who say they are most concerned that the voice will lead to lots of litigation and that this should be avoided are also the same ones who want to narrow its power to make representations, which will indeed be the very thing that leads to the litigation about which they're concerned. If the voice could only make representations about matters directly affecting Aboriginal and Torres Strait Islander people, then this sets up the prospect for court cases about what directly affecting means in any particular case. And frankly, that's just a waste of time and money and really doesn't help anyone. The more rational approach, which was the approach that was chosen deliberately at the time this was drafted, is to cast the net very broadly from a legal point of view in order to discourage any litigation about it and leave it to politics to restrain the voice. So, what do I mean by that? Well, there will be three political constraints upon the voice and how it can operate in terms of making representations. First, of course, the Voice will have limited resources in terms of money and in terms of staff. So it will need to focus on the things that are most relevant to Aboriginal and Torres Strait Islander peoples. Second, the constituency of the Voice is going to be Indigenous Australians. They are the ones who are going to choose them either through election or another means. And if the Voice goes around on flights of fancy making representations on things that don't really matter to or relate to Indigenous Australians, guess what? They're going to be mighty cross about it and make their views heard. So they will either insist that their representatives focus on the things, the serious matters that are of importance to them, or they'll have them removed from office and replaced by other people. So from the Voice's point of view, it's going to be pressured by the people whose interests it is representing to act in a way that reflects their needs. Third, there's Parliament. Under the third paragraph, section 129.3 of the proposed referendum, the Parliament will have the power to legislate about how the Voice is comprised and what its procedures are, etc. So if the Voice is going off doing crazy things and not focusing on its core issue, which is making representations about matters that do affect Aboriginal and Torres Strait Islander people, then the Parliament can, of course, change the law to change the way the members of the Voice are chosen, to change how it is comprised, in order to get a body that focuses more directly on things relating to Aboriginal and Torres Strait Islander peoples. Now, you need to remember that anyone can make representations to Parliament or the executive government, but how much attention is given to those representations will depend upon a number of factors. One of the most important things will be whether or not the Voice has anything sensible and relevant to say. Now, I often make representations to Parliament. That's because I'm normally asked by a parliamentary committee to make a submission to a committee inquiry, and I usually do so when I'm asked. And sometimes my representations may be influential, but that's only because I'm acting within the area of my expertise and I'm giving useful evidence, being factual evidence or a legal analysis, to the committee to help it in dealing with the issues before it. If, on the other hand, I went off and started making representations to Parliament on matters that have nothing to do with my expertise, say, for example, I was making representations on interest rates or epidemiology or what defence equipment Australia should buy, first of all, people would think I'd gone mad. And secondly, they wouldn't pay any attention to what I said other than to think, next time she comes and gives a submission, we'll throw that one in the bin. So ultimately what I would do would be to squander the influence that I do have by A, spreading my representations too thin, and B, giving it in areas where I don't have the relevant expertise. People just would not pay attention to what I said. Same with the Voice. If the Voice goes around making representations that clearly have nothing to do with its area of expertise, the evidence that it can get from people on the ground, that on issues that don't have any significant impact on Aboriginal and Torres Strait Islander people, then it will not only have its representations ignored, but it will squander its reputation and its ability to influence in the future, which would be a very unwise thing. So, for those reasons, it's not the legal constraints upon the scope of what the Voice can make representations about that are important. It's the political constraints upon the Voice that will keep it, hopefully, on track, so that this isn't a matter that really needs to be one of concern in relation to this referendum. Hope you found that useful. Come and join me again for further discussions on the Voice referendum. I'll see you next time. Thank you.